for your guys' awareness, this meeting is a bit different than a normal planning and zoning meeting, which is why we don't have all our commissioners here. This meeting, regardless of what happens tonight, this will be tabled because of a situation where there's recommendations for disapproval because of issues with the health department right now, and the applicant is trying to work out with the health department. So they have requested a table, and that is what we're going to do tonight no matter what happens. We will do a recommendation to table and vote on that. The record currently is not open, but if you would like to speak tonight, we can open the record so you can speak. Understand, though, that if you speak tonight, this is your one chance to speak. There's no, at the next meeting, you'll come up, you'll state your name and address. We take it down for the record. And then when we reopen this for the actual item to be heard with the applicant, the staff report, and everything like that, you won't get the opportunity because you've already stated your piece. So if you want to speak today, you can, but understand that you won't be able to speak when this is opened up. And when the applicant comes forward, some of the questions you have right now might be answered by them after they work out all their issues that they're currently having as to why they're recommending a table right now. So just if you put your name down in the back, that's fine. Only the people that come forward and speak will be counted as having spoken for the record. If you'd like, please go back and cross your name off if you didn't speak, but also we'll be keeping track of who does come forward to speak. So just be aware that we're not going to have the applicant presentation. The staff is not going to present tonight. There's not going to be an applicant rebuttal because the applicant is not here because this is a recommendation for table hearing. So if you would like to speak, by all means, come forward. I'll open the record for you, but understand that it is not going to be a full hearing with full commissioners. And the only way that they will hear your testimony, the missing commissioners, is via the recording. They won't be able to ask you questions or anything like that. So with that in mind, because of that, we will go ahead and anyone who is in the audience that would like to speak, by all means come forward. But understand you will definitely get an opportunity when the full meeting happens, when we fully hear this item with the applicant and the staff present, because the staff doesn't have a staff report because they're still waiting on the health department who is recommending denial of this right now, which is where we're at right now. So if there's anyone in the audience that wants to speak, I will open the record. We will take that and let you come forward and speak. Otherwise, I hope a crowd of this size comes and attends at the meeting where we do hear this, because this is exactly how the system works. So if you'd like to come forward, please state your name and address. Sir, who's raising your hand?
Second question.
Go.
Before anybody decides to speak or not to speak, how long is this going to be tabled, and how long are you going to allow the applicant to find a solution when they have not presented any solutions so far?
As of right now, the recommendation to table is undetermined date. You'll have to answer the other question, Leon.
Chairman Commissioner, that's right. They've asked to table indefinitely, so what that means is we will have to renotice the future public hearing. So new radius notices, there will be new site posting, new published legal notice, and a new agenda. So it will be announced like the original hearing was. There is no set time frame as to how long something can be determined indefinitely. We don't like to see things hang out there for a really long time, and given the interest in this project, we are going to keep a close eye on that, but I don't have a set time right now. I mean, it is really a function of their engineer working something out with the health district if possible, and if not, I mean, there's really not a way forward for the request they've made. So
I think the latest we would actually table anything at a set date would be September at this point, probably, and they're not even there yet, so
yeah, and again,
later than that.
And tabling a date specific tonight would not require renoticing, but we're doing it this way so that we have to renotice per state law.
Yeah, so just be aware that it's almost like the process is going to have to start over because there's so many things wrong with what's going on with the
yeah, and the record's incomplete. I mean, they have they had a information, and they've got a pretty strong no from an agency that's essential to this project. So they've tabled to try to see if they can resolve that, but we don't have a complete record and we don't have a complete recommendation at this point. But the pending or draft recommendation to this point has been denial based on what the health district has said.
So if the health district never comes back with their approval, it's just never going to see
The use that they've requested would not be possible.
Yeah, so that's kind of where we're at. Unfortunately, we're at the mercy of another agency at this point before we can even make a decision. So, I don't. Is it cool? Is it all right if I just ask a question, let them, or do they need it's not a testimony, obviously. I just.
Well, I mean, I guess we can try to answer a few administrative questions,
Yeah.
but we shouldn't be getting into the nuts and
Yeah,
bolts
no,
of
that's-
the project
yes.
because again, we're not opening the record.
Yeah. So if you have like a procedural question, by all means ask. But I'm not going to be able to speak on the project. Go ahead, sir.
I was just going to ask if we could ask some questions. I guess my question would be, they've already populated this house. They have people living there. They're using a van to transport people there during the day. While this process is working itself out, are they going to be able to allow to continue operations unimpeded?
Unfortunately, that's the type of question that we would have to open the record for and understand. If you have like a situation like that, you can reach out to the planners directly. But for the planning and zoning, because the applicants can't not hear, we're not going to be able to speak on the behalf of them. I apologize. So we can't answer questions on behalf of the applicant like that. So, but if you do have those types of specific questions, feel free to reach out to Leon and his team.
Yeah, reach out. I think many of you have spoken to Brent Danielson at this point. You're welcome to reach out to me. I think you've seen a property information request letter that was written about the current 8+2 situation, as I'm calling it. So there is some explanation there, and it is subject to the Federal Fair Housing Act, which there's a lot of additional conversation to have around that. But I'd be happy to speak to anyone that has questions along those lines. But to Commissioner Scott's point, if we start asking those specifics, we have opened the record, you've testified, and you won't be able to really testify again. So we'd like to have the complete conversation in front of everyone when we're ready to make a decision. Yes?
Hey, you said you would address the Federal Fair Housing Act?
Well, I will note that the 8+2 is protected. What they're doing there is protected by the Federal Fair Housing Act. It qualifies as a single-family home. And a family living in a single-family home, if you look at Ada County Code, and again, that property information request spells out how that's allowed. Ultimately, if there's disagreement from this group about that interpretation, it's going to be subject to federal court, an interpretation of the Federal Fair Housing Act as it relates to that property. So that's would be the way forward.
The United States Department of Justice, their Civil Rights Division, has released a statement in the past that a reasonable accommodation does not apply if that accommodation violates any existing zoning regulations or community planning.
Sure.
And we're looking at a situation here where we believe this is going to not fit into the community zoning, the R6, and it does not fit into the long-term.
So I'm gonna stop you right there. We're getting into hearing level stuff. I'm very sorry. We don't have all our commissioners here. We don't have the applicant. If you have procedure questions, I'm happy to answer them. But if it's like what this specific project is about, we're not going to be able to do that tonight because no applicant can defend themselves with a rebuttal, and and there's unfortunately the staff report is incomplete. Gentlemen in the
Mr. Chair,
Oh, sorry, Commissioner Murphy.
just a question for Mr. Letson. Just so people can get an idea of time frame, et cetera, because I think that's, probably something that everybody wants to know about. How many days before a hearing is scheduled does the sign go up?
Yeah, it's required to be up 10 days prior to the public hearing itself.
10 days.
So posted on site, yeah.
So, okay. And then as far as the notices that go out, that is how many days?
We typically do those 15 days at a minimum before the hearing. So that would be the mailed notice that you're referring to?
Okay, so 15 days after is when the next thing, once we know when that is.
Yeah, basically, the applicant would have to reach out and say, we've come up to a solution and we would like to go to the public hearing at this point. So then again, we would start the notification process per the timelines that we just discussed.
Okay, thank you.
All right, gentlemen in the far back, SI first.
My question is, what commitment is there to a subsequent hearing? Because you're saying, don't speak now because you won't be able to speak at a subsequent hearing. But what I'm hearing is the applicant has to initiate that process.
That's correct.
If they never initiate it, none of us ever get to speak.
Well,
What is the commitment to anher hearing?
well,
We have
I think-
I'm sorry, go ahead,
you-
Commissioner. We have an active application, and so the commitment is in the fact that the application is active. If they were to withdraw, there would be no hearing. And so, we don't bring items forward that are withdrawn, but it is a pending application, so it remains in our system, and in order for them to operate per what they've requested, they'd have to go through this process. And
Mr. Letson,
The question would be, how many times and how long can we table this, essentially?
there's no limit on that. I mean, we've had items tabled month after month for a year. I mean, some of our subdivisions with water issues or things like that. But, so there really is no limit there. But because we're tabling it indefinitely, again, we have to go through that notification process. Again, if you table date specific, you don't have to renotice per state law. And so we're doing it this way so that we can put it out there, the specific date that will be
Mr. Chair.
scheduled.
Go ahead.
Mr. Letson, I think part of that question might have been, can they just stay in this limbo and continue to operate if they are operating at all? And if so, how long is that time frame? And at what point does it become a code violation where the law enforcement gets involved?
Chairman Commissioner, again, per that property information request letter that I wrote, as long as they're operating inside of that, they don't need to be here. That is a allowed use in that district. If they exceed that or start offering treatment that steps outside of what is protected by the Federal Fair Housing Act, they would be in violation of Ada County Code. A code enforcement case would need to be opened, and it would make its way to the Commissioner's office and ultimately the Prosecuting Attorney's office to figure out remedies. So
Thank you.
Just right here, green shirt.
Are you saying that if they have 8 people and 2 living there, getting this treatment, they're within the FHA guidelines? But if they're bringing people in, so just like if I was running a business out of my house where I'm having clients come to me, I think
Yeah.
that falls into, if they start bringing people in for the day, does that not fall outside?
yeah, I think there's been some conversation. Again, we're kind of getting into the specifics again, but I'll try to address it. So the outpatient treatment, I think that is advertised on their website. Someone's raised the question, is that protected as well? We have had discussions with our legal team, and they believe that it is still protected by the Federal Fair Housing Act.
That's going to exceed the 8 and 2, once they bring people in during the day.
Yeah, and I think someone raised the question of what does residing mean and that sort of thing. And again, we've been in a lot of conversations with our legal team to get a better understanding of that. I am happy to work with our legal team to get an answer out to you on that is hopefully something that makes sense. I mean, the Federal Fair Housing Act is not something that I spend every day in. It is a federal law, but again, we are subject to it. But from what I've heard from our legal team, what they're doing there now, so long as they're not exceeding the 8+2 in terms of who's residing on the property, the outpatient stuff they've said is protected as well. But again, we can open that again and have some more conversations and see what our legal team says. But that's the answer I have right now.
Inevitably, it'd be the prosecutor that would have to,
Make a determination that it
Yeah.
steps outside of
Which-
what is allowed per a family and per the protected class.
which is well outside of our purview.
So we would start calling code enforcement once we see them trucking people in and out every day.
Yeah, and again, the issue's been made, has been raised, and again, I've talked to our legal team, but I think more information we can certainly accept, and we can have them dig into it deeper. I wish I had a better answer for you on that. I'm sorry. So,
Man,
Me,
yeah, go ahead.
I would like to testify. I think I can kind of voice some of the concerns of everybody here, and I'm willing to forego my future testimony.
Okay.
I can let me get you set up here, Carol.
Can I ask a quick procedural question before she testifies?
Sure, what's up?
So if we choose to testify tonight, that is still gonna be a matter of record. The applicant just won't be here, but all the commissions will hear that. and
They
see
will.
that and take anything we say fully into consideration.
That is correct. They will hear it through the recording, the absent commissioners and such. So, Commissioner Birch?
Yeah, as Chairman Scott has said, the applicant can come back and revise what they intend to do. And so you may be speaking to what you think they want to do now, but when it comes back, whenever it is, you may have spoken to something that is completely different from what they are then proposing.
I understand, but I think enough of us are here that at least to let you have a sense of why we all showed up tonight, even hearing that it was going to be tabled to a future date.
So
I want the commissioners to understand why we're so concerned right now.
So,
And I brought a PowerPoint or PDF so that you could visually see it.
Do we have to make a motion to open the record, or you could just open the record, right?
I think I can just open it, but I'm going to double check. Yeah, that's not a motion thing, because I open the record with business anyway.
Right.
Yeah, so.
Yeah, you can do that.
I'm sorry. Anything that could go wrong technically is happening today, so. Hey, Luke, can you,
All right.
sorry about that. It's just not reading the thumb drive, and I don't think it's your thumb drive, I think it's.
Oh, yeah, right, Rod down there.
Yeah, no, I brought thumb drives before, so it worked before.
Just right.
I'm having some issue getting this thumb drive to register. Where's the thumb drive? That's the blue one there? Is there another place to?
Plug it into the tower.
Oh, yeah, maybe we could just do directly to the tower. Do you have a, is that the same one? Let's see if that one registers first.
Pen is my
Oh, my
pen,
bad.
but you're welcome to use it.
No.
Put it there.
I
if you
leave
need it.
pens here so much that I just bring crummy pens.
Yeah,
now,
this
so.
is that, let me try it down here.
Yeah.
We'll do that. Maybe
It's in the
that's.
gray one, by the way.
Yeah.
Who knows what the assessors did?
Oh, boy. That went from bad to worse, so let's.
Tonight, you didn't get any of the nasty coordinates. No.
Well, at least was it the worst? When you pull the, at least it's making a statement there.
It was border.
Borderline.
I've had worse, but not a whole lot.
Pizza, we got YouTube down, we got us streaming, we got.
How's Leon gonna insult me with this pizza on my anniversary?
I think there's some you could take home.
I'm not going to.
Yeah, there's probably a little bit.
Yeah, I'm good. Although my kids would be like, "Yay, pizza! It doesn't matter."
All right, sorry. Lost power, but we're getting it back. It'll be just a second. So.
I think this meeting is closed.
Oh, man. Really? Are these? There we go.
Day for technical difficulty.
Yeah, it was the Board of Equalization that broke all our stuff. So send your letters to them.
Yeah, yeah.
Assessors messed up the whole room and everything, TVs and stuff, they just took over.
I'll log in.
Will it go straight to our computers, or does it need to go up there? I mean, because we
Go to
can.
both.
What are you guys seeing right now?
Well, I'm just seeing the hearing agenda, but I can control Z or shift Z over and see.
I'll go here.
Okay.
If this is never on, if this is not on, tell me and I'll come and turn it on for you guys.
Yeah, shift Z is not. It's just saying HDMI input missing.
Get a little right a list of how many things went wrong today.
Jeez.
Opens up, you can go ahead and skip to the second slide right away, since they've already said it will have to be tabled
Sure.
tonight.
Sounds good.
Yeah, I'm got it. I think I got him.
Waiting for this computer to wake up. So.
Yeah, yeah.
Pull that out.
Yeah. I didn't realize it was going to be such a.
Let's just,
Yeah, this is attached to some other stuff, Carlos, that we need. So sorry, it's just. It's the other one where the million profiles are loading.
But what they're doing is they're riding the line by having people.
Well, it just came on. Is that off over there?
this is the other one.
Well, no, I just. Oh, it always just is off. Okay.
Black because there's nothing on.
I do have it on my computer, but
We're there. We're getting really.
Just came up just when we said that.
So do you have to get these back up? Oh,
Here we
okay,
go.
Good. All right, we found it. You're there. Do you want to make sure everything's working back there?
There you
Yeah, we'll introduce the slides as part of the record. Well, I'll tell Leon. I don't know what number it would be, but he'll figure it out.
Computer's on.
Yeah, I think
Retrial. We're gonna do that.
we just need to open it now, so we're good.
All right, you said start on slide 2, Carol?
Yes.
Okay.
All right.
Okay, my name is Carol Vidales, 10963 West Oleana Drive, Boise 83709. Our concern is that although they've requested a conditional use permit for a residential care facility, to all of us, it's pretty obvious what they're operating is a medical facility. And per the Ada County Ordinance Code, a drug and alcohol abuse treatment center, all that kind of stuff, requires a conditional use permit. It's not just automatically allowed. Next slide, please. I had on that slide the link to their website and their press release. May 15th, they issued a press release. This is the first page of the press release. They're talking about the Mental Health and Addiction Treatment Center. Next slide. These are these are just excerpts from that press release, but everything they're talking about is a medical treatment dealing with substance abuse and mental health diseases. Next slide. This is the very bottom of their press release. Those pictures are from the Chapin facility. They link here to their website, their blog, and notice the hashtags at the bottom. They're all dealing with rehab, addiction treatment, medical things. I mean, any person off the street, it's medical. Next slide. If you click on the website link, this is what you're brought to. They're advertising their alcohol and drug rehab programs. Again, it's not what we consider a residential care facility. They may be people that have had drug addiction in the past, but it looks to us like they're currently having the problems and receiving treatment, so it's ongoing. Next slide. Again, this is another part of that. They are calling themselves a substance abuse and mental health treatment facility. Next slide. Here are the definitions in the Ada County Code currently for drug and treatment, alcohol treatment facility, and residential care facility. Residential care says it's non-medical. Everything that we hear, I mean, we're a whole bunch of people, and all of us are in agreement when we look at it. This is medical. So it wouldn't qualify, even if they're protected, under residential care. Next slide. Now, drug and alcohol facility actually, as I read the table, isn't allowed use in the R6, but you have to have a conditional use permit. And we feel like we're being denied the chance because they already delayed it for May 8th. Now they're delaying it again. We have a concern that they'll just operate under the table and never come back, and we'll never get to say our 2 cents. And it says that the alcohol facility is supposed to maintain a license from the state. I actually filed a public information request with the Department of Health and Human Welfare 10 days ago. I've heard zilch. So who knows if they have a license. I did end up talking to Facility Division. They do not have that, which the code says a residential care facility is supposed to have a license with the facilities. So.
Chairman Scott, I recommend, given the unusual nature of this meeting, that we give more time to.
If you'd like, I'll give you a couple more minutes. We'll just
Okay, well, next slide.
2 more minutes, good? Do you think?
Okay, yeah, that's fine. I only have a couple more slides. Actually, before the house was even their house, they were advertising as of, they got a national provider information. They list their taxonomy codes when they report what they've done to insurance. So you can see there, they're calling it, they're breaking the cycle, but the address on the right is the Chapin address. They have a secondary taxonomy. They have one for the mental health, one for the alcohol and drug abuse or substance abuse. And you'll notice in the bottom right, there's no state license listed there. I don't know if they've gotten one yet or not. We don't know how they're operating. You know, I'm trying to find all this stuff and research can't find it. So all of their own words, they're a drug and alcohol substance abuse facility. And that's what concerns us. They're just being allowed to operate. And we're like, who in the county verifies that they really are a residential care facility? Their lawyer says they are and threatens us with federal fair housing, and everybody just folds. And I spoke with Lori Bedigian at Central District Health today. She said that her hands are tied at this point because of this federal fair housing, that she spoke with the Department of Environmental Quality, and they said, oh, because they're saying federal fair housing, there's nothing they can do. So right now, with 8 people and 2 staff and however many day patients, they can just operate their septic. So anyway, those are all of our concerns, that we feel like we're not being heard, and yet they're being allowed to operate.
Thank you very much.
Thank
Does
you.
anyone have any questions? Please refrain from clapping, please. Not clap during public hearings. We try to maintain some sort of decorum here in whether it's supporting or against. Thank you.
I do have some questions. If you could return to the podium, please. So I've read the letters that were submitted in opposition, and there's more concerns than what you have just raised.
Yes.
Why don't you elaborate on what some of the other concerns are,
Let me
please?
get my computer. Well, they, for instance, the things that we're being told, when they applied for Central District Health, the application says that they certify this information's correct to the best of their knowledge. They said on the application there were 9 bedrooms and 3 bathrooms. The lawyer, when he submitted the application, 5 bedrooms, 4 bathrooms. So this is serious business for us, and they don't seem to care enough to get everything correct. They comment multiple times, there's a 6-foot privacy fence all around the back. Actually, they have a lot of mature, like cypress trees in the back, but it's a 3-foot chain link fence in the back. And they apparently, from their website, are accepting people that are drug ordered court rehab. We have a concern, some of these people, they may not want to be there. They talk about in their thing that everybody there, that they can only be outside in the backyard with supervision. They cannot be in the front yard. A number of people, we have a couple people in the neighborhood that one neighbor actually has, some type of drug and alcohol treatment facility that they work at. So he's aware of all this stuff, and he's already sent a letter saying, all these things they're doing are medical things. They probably have drugs locked up in the facility because these are not people that can just self-medicate. And when I actually spoke with the facilities division at the Department of Health and Human Welfare, they were talking like, oh, we give that license to people that, it's assisted living facilities. And so it's like, as a citizen that's not well-versed in all of these things, to try to figure out the ins and outs and what's allowed and what's not allowed, it's very frustrating. But people also have the concern, we have neighbors that are former law enforcement and also in code enforcement. And prior to this house being remodeled, it was basically a slumlord operation. If you look at Central District Health's history, they were in violation multiple times. The sheriff department listed a report there and said that they were having multiple people and they weren't permitted to have a group home or a boarding house. And in fact, when the guy that sold this house after it was remodeled and rebuilt to Icarus or Platypus, when he applied for his building permit, one of the things he had to apply for was to remove the unpermitted back portion of the house. And like I said, so there's all these things, these neighbors have had to deal. I live just down the hill, and I walk on this street every day. It's a gorgeous view, so I love it. So I've seen all of this stuff, and these neighbors have had to deal through years of having a dump next door, and all these people, some neighbor had the girlfriend show up and wouldn't leave his property, had to call the police. So they didn't get a lot of response from the county then. And so the concern is like, well, if these guys, since they don't seem to care about us at all, or if they do something bad, are we going to be able to count on the county in the future? Because we didn't in the past.
Commissioner Birch.
So are there concerns by the residents in the neighborhood about the type of individuals that are at this facility?
Please refrain from speaking. This is the last time I'm going to say it. Do not clap. Do not speak out of turn. Thank you.
Yes, because especially some of these people, these are people that if they were through their drug rehab and doing okay, they wouldn't come to a facility like this. And so people can have breakdowns. I mean, and some of these people have co-occurring disorders. So they could have PTSD as well as substance abuse. And also, this facility only has 5 bedrooms, and they were wanting 16 people in there. Even with 8 people, you're going to have to be sharing. Now, you can imagine what it is if you people that are already got mental challenges, and they also have substance abuse, and you're crowding them together, and they can only be in this backyard. And they, you talk about what activities they're doing. They're mentioning yoga and stuff like this. It's like,
So have there been any issues thus far with the people that have been at that facility?
the issues that I have heard thus far has, a neighbor on one side has a young child that's 5 or 6. The neighbors were hearing a lot of F-bombs thrown around. And from what they could tell, it was actually the supervising person that was doing this speaking, which they kind of wonder, like, why are you talking to your patients like this? Also, it was heard somebody was yelling, "I've been shot!" And I want to tell them in the future, if you hear something like that, call the sheriff and just say, "I heard this, I can't say anything else. These are people with potential mental and drug problems, so who knows, but that's what I heard." Also, there are security cameras around this house that seem to be, because they're looking at the sides of this property, it, by nature, just goes further than the side, and so now they feel like they're being spied on in their backyard on either side.
Have there been police or ambulances that have come?
I am not aware of that.
Okay. And can you kind of describe the
Commissioner
neighborhood?
Birch, can I interrupt real quick?
Yeah.
I have a bit of an issue here because we do not have the applicant here, and we're starting to go down a route of a lot of question and answer without an applicant's ability to receive the rebuttal. Did you tell the applicant that they were not required to come here? Or they
Yeah,
just?
Chairman Commissioners, yeah, it's, it's very typical that the applicant doesn't attend a hearing to table an item because they know the hearing will be opened at a future date.
So I'm just concerned, Commissioner Birch, and I'll let you continue. I'm just voicing that there's no applicant here to defend themselves. And so now we're going down, I was going to open up the record so that we could hear their 3-minute briefings, and we're answering questions now. That is going to be a lot of going against the applicant. And in order for fairness, I think the applicant should be here so that they can address those concerns, but just voicing my concern there.
Chairman Scott, this may be unintentionally an advantage to the applicant because the applicant can now, when they come and make their presentation, have heard some of these objections and can respond to them at the outset.
No, yeah, that is correct. All right. I'm just, I do worry about that from our legal side too, though, given the opportunity. But I agree with you, that is an advantage, but also I worry about staff and the aftermath with legal allowing us to have what's becoming a large testimony without an applicant here to rebut.
Yeah, Chairman Commissioners, I agree that, we should try to, for those who want to speak, keep it within the 3 minutes that we can. I know that you typically like to ask questions of members of the public as well, so I'd encourage you to strike a balance there somewhere and know that we will have a lot of additional testimony on this item in the future when it comes back to a public hearing, so. Okay.
Yeah, and I will say, with respect to that, Chairman Scott and Mr. Letson, the reason I'm asking the questions I am is because I know a lot of the people here that are in attendance probably are thinking about what their objections to this proposed facility are. And I'm just trying to get as much as I can from this particular individual out in the open so that it addresses the issues that some of these people are undoubtedly thinking about. So I do have one last question, and I think Commissioner Murphy then has questions. Can you describe the neighborhood for me? The average age of the neighborhood, how many little kids there are in the neighborhood, that type of thing?
There's an elementary school a half-mile away. The neighborhood itself tends to be it's closer to half-acre lots. So when they notice it, it's only a few houses that get the notice. This house in particular sits on a hill, and there's no house directly across the street, so it has a nice view of the mountains. But the neighborhood's kind of in flux. There are a lot of older residents that have been there for 20 years or better. And some of them have the concern that, they're going to be getting to the point where they'll have to sell, and they are concerned whether this will affect their property rights or their property values. But you have more new, younger families now moving in as the older families that have been there a long time, and they do have younger kids. There is a bus stop almost right across the street from this where children get off. So there's the concern that if somebody did escape, our understanding is if, they're supposed to be out there under supervision, but you'd have like one staff for 8 people, and if somebody did decide to just leave, that they won't stop them. And then what happens if the school bus is there or, so nothing has happened yet. The policeman that lives in the neighborhood has commented that he was a Meridian police officer, and when they opened one of these in his beat there were increased calls for just, people, noise, or, they would leave and walk around or bother people or go to someone's house and not leave. I don't know, I haven't heard of any theft or anybody leaving this house so far, but it's a somewhat rural community in a sense. It's, Ada County is pushing south. I live in Hazelwood Village. You'll recall the Lockwood lot that we were here a lot about. So this is just a little, there's, you go south of that, then you have the school, and then you have Chapin.
All right, thank you.
Commissioner Murphy?
Thank you, Mr. Chairman. Carol, is it?
Yes.
Have you or any of your neighbors documented, whether it be probably with photo evidence or other evidence, the quantity of people that are at this particular place? Like,
What I have been doing is, like I say, I walk on that street at least 5 times a week. Sometimes I walk it twice a day because it's just a really nice walk. And so what I've been doing is writing the number of cars, and then more recently, so I'll write the date and the time, and like it was a white SUV or a black Jetta or something. But more recently, my husband advised me, start putting the license tags. So they have a camera on you, so it makes you a little bit nervous, but I've been trying to write the license tags. So because they do have the 6-foot fence on the 2 sides, it is difficult to see. I spoke with one neighbor that lives close by. It was probably about 2 weeks ago, or 10 days to 2 weeks, and they had seen evidence of 4 people at least. However, there has been a white van that will show up, and it will pull into the garage, and because their website has discussed having day patients, we're concerned that that may be a way to get around the septic permit. But we don't know, and so it's not a house where we're going to go and knock on the door, hey, how many patients do you have?
right, just curious if you see people coming and going, et cetera. And then hold on for me 1 second. Mr. Letson, the original call is asking for a conditional use permit for a residential care facility for up to 16 adults. That was the original, right? And so now that ask has been put on hold, or is it the same ask?
Well, that is currently the ask. They so they haven't modified their request at this point.
Okay.
That is what they're trying to
Okay.
get approval for.
And then how long can one continue meetings before it?
Tabling meetings?
Yeah.
There isn't, again, anything specific in code that limits the number of times. I think there's a reasonableness consideration that has to be made by, the director or P&Z or the board to say, hey, this is just dragging on, and, we have, they've paid a fee, they've submitted an application. It's all pending right now, but yeah, there's no time frame in our code that says how long they can table. So
Okay. Thank you. And thank you, Carol.
Thank you.
Commissioner Wickstrom, did you have anything? I know you're on the phone listening. Can you hear us? Is he still there? Boy, I hope he's still there.
he's on the phone. Hey, Rod, did you hear Chad's question? Sorry. Oh,
Yeah, he's there.
Rod, do you hear us?
Yeah, I do. Yeah.
Chad, Commissioner Scott, sorry, wanted to know if you had any questions of Ms. Vidalis.
No, I don't.
Okay.
Thank you so much for your testimony. Is there anyone else in the audience that wants to come forward to testify? All right, Commissioner Birch?
Yeah, I had another question for Mr. Letson relating to what Commissioner Murphy just said. In the 5 years that I've been on this commission, I've never seen anybody do this, but I know that one tactic could be to drag these people out repeatedly and table it at the 11th hour. And so is there any way to stop that, where if they want to table it, they would have to give at least, 24 hours or some notice?
In the event, I'm sorry, Chairman Commissioner, so you're saying they come to us with a date to reschedule, renotice, and then they try to table it again at the last minute? And
When all the people have showed up,
Yeah.
figuring eventually they'll wear them down.
yeah, I mean, we're definitely getting into some legal territory as to what your ability is to deny a request to table an item and force it to be heard.
Trying to find a mute button. Not screwed up on his phone. So
Hey, Commissioner Wickstrom, we can hear your conversation. I don't know if you can hear me.
I don't know.
Or was he responding?
Sorry, I lost my train of thought there, Commissioner Birch. Again, I think what you're asking, and maybe what the public is interested in knowing, is could the P&Z reject a request to table an item and just force it to be heard? I think technically yes,
I was told I was here very short.
and so we might
Very short.
have to explore that. Sorry.
Something to consider. How many times have we tabled this? Leon, do you know how many times we've tabled this? How many, this would be the second?
I apologize, it's not my application. I believe it's at least once, but twice at the most that it's been tabled at this point. Twice, thank you.
Okay, so I guess that's a question, like, do we want,
Yeah,
how would we do that? Like, would it be just a recommendation of a specific date, even though it's undetermined by by staff?
Yeah, I mean,
But what happens then? They'll just say, well, we want to table it again, and we
I
can't.
mean, they can always ask to table, and again, at some point, this body can decide we're not going to table this item anymore. So if you were to pick a specific date, we wouldn't have to renotice, but everyone in this room would know that specific date. The applicant would need to comply. And again, if they ask to table again, I think you'd have the ability to deny that. I wouldn't encourage you to denying it. Well, it's difficult to deny it based on the fact that the record isn't officially open, so you haven't had an ability to look at the facts of the case and determine the findings. I mean, it's really just, yeah, that's a complicated one. I'm sorry. I wish I had a better answer for you.
so I have a proposed solution, and that would be to talk to the applicant and let the applicant know that if they don't give sufficient advance notice, that there is a strong possibility that this body may deny the ability for them to table it, because all we're trying to do, and again, I'm not saying the applicant would do this, but we don't want any appearance of anybody just jerking people around and having them show up to wear them down. And so if they said, look, if you want to table it, give us 48 hours notice. Otherwise, we may refuse your request to table.
Yeah, certainly. I think we can communicate that to the applicant. And, yeah, I mean, I guess it's even technically at the power of this board to say we're going to actually set a date, and that's going to be when people come back to hear this, and we won't allow it to be tabled again. That gets complicated again if they. We're getting into an area of how that works legally that is a little complicated. But again, I'd be happy to share some backup hearing dates with you if you wanted to consider
Chair.
a specific date.
Commissioner Murphy?
Mr. Letson, typical, and I know things aren't always typical, but they're redoing, they're working through septic and Central District Health. That's pretty much the reason for the table, 100%, right? Like, how long does that really take? I mean, and
I mean, Chairman Commissioner, I've seen that
just
all
a
over the
dart
place.
at the wall. Like, is that a 6-month process, you think, or?
Yeah, I mean, I think I mean, for larger subdivisions, we've seen it drag on for a long time. It comes down to how quickly they can prepare the studies that the health district needs. I would have no guess as to how long that would take. I think it should be reasonable that a property of this size and, you know, a structure of that size not be as complicated as a, you know, 40 lot subdivision or something like that. So, I mean, again, I'm just throwing a number out there. You could say August backup hearing if we wanted to do a specific date. If they can't make that, then they could ask to table again. And again, it'd be at your discretion to say, we're just not going to table it again, and we're going to have to hear it tonight, and they'll have to show up prepared to speak. I mean, I think they'd have some grounds for an appeal to say, you forced us to discuss this without the evidence we needed to get support. But, you know, again, that we're entering into like lawyer territory, which, thank God I'm not a lawyer, I'm just a planner. So, all that to say, yeah, I think you could pick a backup date in August if you wanted to say, hey, 60 days basically to get this sorted, and we need to hear it.
Here's my concern on that is we're missing a good chunk of our board here under the impression that it was going to be tabled as the staff recommended. So I think I agree with you, Commissioner Birch, absolutely, that there needs to be a date, but I don't think we should be importing that date this time. If we will table it as the staff recommended is my suggestion, and then if they try to do this again, that is when we not necessarily shut it down, but you know what I mean. We start putting timelines on them. That way, we're in accordance with staff. It gives a bit more of a legal strength. We can bring the whole board in to participate, and so.
Good idea.
Yeah, so.
Okay.
All right. Just want to, once again, last chance, anyone wants to come forward and speak. If you're just asking a procedural question, that's fine, go ahead. But if you want to come forward and speak, please come forward. You, sir, over there. State your name and address for the, excuse me, for the record. And just understand that this will be your opportunity to speak. You'll have 3 minutes.
Okay. My name is Alexander Gurtoy. My address is 6850 South Santa Cruz Drive. I live in that area for 15 years, and I'm really concerned about safety for our kids because I have 6 kids. And I did addition to my house 7 years ago, and there was only 7 people at that time who lived in the house, and Health and Welfare forced me to put a big septic. And I didn't add any bedrooms, and my property is at least twice bigger than the property we're talking about right now. So that property where they're trying to open this business has not enough land to put a septic to serve so many people there. And another thing, I had one time breaking in my cars at night, and biggest concern, my kid was kidnapped by one of the neighbors in my area. It's 2 houses down, and my wife, she freaked out, believe me. It was a really bad experience for us. Police came, and when they talked to those people, they took my kid and put inside their house, which not allowed. And when police came and talked to them, those neighbors moved out in 2 weeks. So I don't want to have any experience with any neighbors going through that. And another thing, the school that we're talking about, if you stand at the front of the driveway, you can see the school downhill. And you can see the kids when they're outside or inside the school. And you cannot control those people because they can easily watch it when people are playing on the playground. And I'm sure that school doesn't have enough security to protect those kids. I'm driving by that house, either me or my wife, every day, taking my kids to that school. And I'm really concerned about safety of our neighbor kids, even elder people, because if there will be some thefts, there will be claims filed to insurances. Insurances will definitely go up because of the claims. It will be, I would say, disaster. And I don't want to have anybody going through any of those bad experience. Plus to that, businesses are prohibited in that area. Those people who try to open the business to make a living and work 8 to 10 hours a day, they have to close and moved out. And this business runs 7 days a week, 24 hours a day.
Thank you. Do you have any questions?
More of a comment than a question. You will not be permitted to testify when this comes back again, but that does not prohibit you from writing a letter, addressing all the points that you've just made, and making it a part of the record. So since you can't speak again, you might consider whether or not you would want to put in writing some of the things that you've just spoken about.
Okay. Thank you so much.
I'm sorry, sir, there's a white piece of paper. If you could fill that out for us, just so we can have you on the list of folks that spoke.
Is there anyone else that would like to speak? Oh, did I just interrupt?
I'm filling it out, you just hand it to me. Oh, yes.
Question.
Okay.
Why was the applicant not here tonight if their item is the only thing on the agenda and it would enable the commissioners to be able to appropriately take this up?
They requested to table it, and when it's a request to table, it means that there's not enough evidence to open the record. The record is incomplete, and therefore, they're not required. And
Knowing that you could choose not to table it?
well, we could choose not to table it, but then we go down a path of appeals that will absolutely be approved. So understanding procedurally that a table at the request of the applicant, if we were to override that, would immediately go to a problem of appeal, and it would become, our legal team would end up over. And also, yeah, it's a situation that is quite typical, and I know that Leon has made every effort, he and his staff have, to announce that this is going to be tabled, so.
We did try to reach out to a lot of folks to save you the time, come down, but obviously showing up, this means a lot to you. So thank you for those who made it.
And
I have a quick announcement. Is there a Rachel Morehouse in here? They found your credit card in the security, so. Sorry. Or this gentleman right here. Sorry
just,
about
yes, ma'am?
A procedural question. So, did you mention earlier that there would be a mailing of notification for the next public hearing as well as the sign at the end or out front of that property?
Leon?
Yes, that's correct. Because we're not tabling it to a specific date, we will send a new mailed notice, require a new posted sign, publish in the paper again, all that.
Okay, well then, what are the requirements for being on that email list?
Well, so the Ada County Code requires a radius notice of 300 feet. Ms. Vidalis brought that up from the boundaries of the property. So all property owners within 300 feet are sent a notice. We also transmit to the neighborhood association in the area, so that's Southwest Ada County Alliance. And it sounds like they're talking quite a bit about this as well. And so, yeah, that's 300 feet from the property boundary is the requirement. So.
And you could also call it.
Problem as far as, if the person from Ada County Alliance, in the, overall neighborhood posts to, like, next door that this meeting is happening on this day.
No problem at all. The power of Nextdoor is something we see all the time. It's how communities talk to each other. So yeah, no issue at all. We want the word out. We're not intentionally trying to limit people's participation in projects. We just have state codes and county codes that regulate what we're required to do. If we have more procedural questions, I could maybe just answer these after the hearing, but.
Okay, yeah, well, I'll take like 2 more questions on that because Mr. Letson is going to be available. And then also, your engagement here absolutely doesn't need to stop. You can reach out to the planners. You can keep an eye out within your communities as well as write letters and things of that nature to keep this going. Yes, ma'am?
Yes, I'd just like to ask, because we have seen a number of changes take place in proposals, and I'm with the Southwest Ada County Alliance, and we would really appreciate the applicant giving us an opportunity at another neighborhood meeting to update us, because to come here and hear changes that we really aren't familiar with is not fair to us when we return for the public hearing. So, you know, I know that this is unusual, but considering the number of requests that the applicant has made for tabling and inconveniencing us, I don't think it's too much for them to arrange for, you know, a neighborhood meeting at the library is just below them there. I think that would be really helpful for people that are here tonight to have an update on you know, the next hearing. So
With a renotice, do they have to have another?
Yeah, Chairman, Commissioners, they're not technically required to have another neighborhood meeting. However, you're aware that you've tabled things and required additional open houses or neighborhood meetings. I think you could ask for that. They, again, may have some legal challenge as to where in the code they're required to do that, but we did that with the zoning code rewrite. As you recall, we did 3 open houses out in the community following. Now, we were the applicant there too, so we kind of, you know, agreed to do that. But we could certainly make the request to the applicant to hold another neighborhood meeting prior to the next. If they choose not to do it, you know, obviously there's going to be a lot of disappointed people here, and you're going to probably hear about it at the public hearing. But I think you could.
We can put a recommendation in there, and if they choose to ignore our recommendation, I guess so be it. I'll take that
But they've
into
met the
consideration.
requirement for neighborhood meeting.
Yeah, and I understand.
But I think you could make that recommendation.
Yeah, for sure. Something like that, yeah. Yeah, no, I think that's valid for sure. So what, so you, sir, in the blue?
I understand they need a conditional use permit to operate, correct?
Is that,
For the requests they have before this group, yes, they need a conditional use permit.
Why are they allowed to operate without one?
because they're technically underneath the requirement. If they are violating that, and that's what came up earlier, that's a code enforcement situation. And we highly suggest you reach out. If you're seeing proof of them going over that 8+2, reach out to code enforcement, and then the prosecutor will get involved. But if they are within that 8+2, they're within code. That's the difference. I'm not sure about that one.
It's it's routed to our prosecuting attorney's office. Usually makes its way to the civil side of that office, and they, a cease and desist letter could be issued, and then follow up misdemeanor fines, penalties, things like that is how that process can go long term.
But understand that federal law can override that if it becomes.
Yeah, I mean, if it's a challenge per the Federal Fair Housing Act, again, the federal legal system is going to get involved at some point here. So.
All right, I'm going to take one more question. You, sir, right there, raise your hand.
So you talked about procedurals and operating at an 8+2. Central District Health denied the septic system for that capacity.
So I'm just talking procedures of the body, not what's going.
If Central District Health has denied their application to operate any type of facility there, they should not be allowed to operate at any number, correct?
Chairman Commissioner, I think that's subject to the health district's decision. I think Lori has spoken to some of you about that. Again, it's considered a single-family home right now, and again, I don't know the current status of the septic. It sounds like the original residential.
In the application, she said it's only feasible to operate at 5+1, 6 people.
So again, I don't know what the health district does in the event that someone puts more people in a single-family home than what the septic tank can handle.
Violation of code.
So again, it's not our code, it's the health district. So I think that question has to be directed to the health district. But I don't know what the health district will do with that. It sounds like she's not going to do much with it based on what someone else just
Yeah,
said.
because we handle specifically occupancy. And if they're under the 8+2, they're fine. If they're violating it, then that is our code side of the house. But if they're doing things that are wrong with regard to health code, it's Central District. If they're violating, it's just like if they're parking wrong, you don't come to planning and zoning for parking. You go to ACHD and the sheriff on that side. So unfortunately, we're all very much stovepiped in our specific areas. So understanding that you come to us, we can't enforce other bodies' codes. We can transmit and kind of share, but it's a situation where unfortunately, so it's meant to be so we don't have like this all-powerful body other than obviously the Board of County Commissioners. But at our level, we're very much stovepiped with like the ACHD board, the Planning and Zoning Board, the tax board that ruined our stuff today. And You know what I mean? So,
Mr. Chair.
yeah, go ahead.
And then just to kind of follow up, the original application was for up to 16 adults. Correct. Right. So I think that's part of the problem why they're having hiccups over at Central District Health is because they are not able to accommodate that many people. And so that's one of the main reasons why they continued it. They tabled it. They want to table it is to try to address that issue, because if that issue doesn't get resolved, that'll be a denial at that point. So they are looking into that. But again, as Chairman Scott said, that's the CDH is looking at that. But that seems to be their big speed bump right now.
Yeah, unfortunately, I can't overarchingly say we're going to do X, Y, Z because of what they're doing now. We only can address their application. So when they do come to us and you guys all come back and we finally have this hearing, that's when we will be able to make our determination. Until then, it's strictly a code enforcement situation. I mean, we hear your concerns, but understand telling us is not going to be any better than telling Leon's staff so he can get a hold of the proper code enforcement bodies and whatnot. So, all right, I'm going to take these last two for real, and then we're going to move on procedurally. So, red shirt, thank you.
So I know we're tabling for the septic, but when do we address the fact that they're running as a medical facility?
We're tabling for everything right now. So everything is being tabled, and then once the applicant says they're ready for their hearing, then that's when that hearing will take place. We'll set a date, the staff will set a date, and then the notices will go out. Until, what I assume, with the applicant not being here, what I assume the applicant's trying to do is going to be find a way to get where Central District Health approves it, because I can tell you without a Central District Health approval, there's no approval, period. So until they get to that point, they are required to operate in their current status and what their current zoning requires. And if they're violating that, it's on you guys as the neighbors seeing this happen to get a hold of the code enforcement people. But for now, the whole thing is being tabled, and we will address the whole body of what is going on, septic, number of occupants, everything like that, when the actual item comes up for business.
If we just keep tabling it, then they can just operating as they are.
Well, that's what we're going to address here, is we're going to table it, and then when it reopens, we're going to, and I can't speak to future, obviously, because we have other commissioners that might be present at that time, but what the likely recommendation is going to be is no matter what, you're going to have a date the next time and such. So, but until then, unfortunately, it's going to be tabled until that undetermined date, knowing that it's not going to go indefinitely. And if they are violating the 8+2, please notify the code enforcement. Go ahead, Commissioner Birch.
Yeah, I think that the question that was asked could be interpreted as, well, could they do what they're doing now indefinitely, even if what they're doing is in violation of applicable law? And unfortunately, and this is something you're not going to want to hear, but who you really want to talk to is a lawyer who deals with these issues. Because then you can say, if you don't stop doing what you're doing, we're going to take you to court. And the lawyer can advise you whether or not you've got a case and how strong your case would be. But unfortunately, lawyers cost money.
Yes, sir.
So, given the nature of a lot of the questions that were put forth today and prior, will you have your attorney here at the next meeting?
Unfortunately,
Is there any way for us to maybe have somebody from code enforcement here as well? Otherwise, we're spreading ourselves out to a bunch of different meetings, trying to contact a bunch of different people.
I'll let Leon answer.
Attorney chair there, they could be helpful, even if it's just an opinion.
Unfortunately, that attorney's chair is for the Board of County Commissioners, the elected body, but I'll let Leon.
I can try to speak to that. Yeah, the prosecuting attorney's office represents the board, not the Planning and Zoning Commission. And they do that intentionally so that in the event something's challenged at this level, the board can be represented by them at the final decision. So they do not come to the Planning and Zoning Commission hearings. Your question about code enforcement, we have had them participate in these public hearings, so we could make that ask to have them share their take on how they've regulated these types of uses or been involved with this property. So I can make the ask for the code enforcement.
Is there any way to get that attorney here?
No, unfortunately.
He's not a part of this group, but.
I'll ask them, but it's been asked several times, and they've clearly stated that they are essentially representing the board's interests at all times. And so because this could be challenged at the next level, it becomes a muddied situation where they're representing one body and then the next body whose decision was appealed. So they do not attend the P&Z, the county attorneys.
Because if we vote to approve with the lawyer here, and then the big commission that's elected votes to deny, at that point, there's a conflict with the legal side of it. So that's why he represents the elected body and not us, unfortunately.
Right, Mr. Chair.
Commissioner.
And then also, sir, the lawyer, as has been said, does represent the county, and they're not going to really give advice to an outside issue, because that would be kind of violating the attorney-client privilege kind of type of thing. But there are enough people here where I'm sure resources could be pulled together to have someone represent your interests should it get to that. I hope it doesn't get to that. Hopefully we roll through this, but something definitely not to ignore.
But we are the county.
And that's a good point. And I wasn't trying to be divisive in my answer there. It's essentially the leadership of the county has the attorney advising them, and they don't provide advice at public hearings. If the county ever seeks advice, they actually table it and require them to meet with them and discuss it. So the attorney's not providing legal opinions during our public hearings, just to let you know that's how it works at the board level.
And I do agree with you, by the way, but as far as that is concerned, but yeah, it's a different little setup there.
All right, we'll go ahead and, I'm gonna go ahead and move this to motion. So I looked to one of my fellow commissioners for, obviously the recommendation is to table to an undetermined date. Obviously, there's some caveats that should be added to that with a recommendation for a public hearing, or not public, gosh.
Specific date on the next,
No, it's, we're asking for, recommending the applicant hold another neighborhood meeting
Yeah, sure.
with a recommendation for that.
Within a certain period of time.
Sure, yeah, that's fine, within 60 days.
45 days.
My concern is, I would say within 60 days of their hearing, because I don't want them to say, okay, we'll have a meeting in 2 weeks and then we're tabled for an additional 5 months, you know what I mean?
But maybe 60 days may be too far, because then if they have a meeting in 60 days, then the actual event probably won't happen for another 30 or 60 days, right? Or no?
We can make this recommendation, just
You think, like,
understand,
30 days or 60 days, what do you think?
30 days prior to them coming to a hearing, it's a recommendation, they don't have to follow it technically, but understand that we'll ask if they followed it.
Right.
So.
Right. Well, I'm open to whatever.
I'll just-
suggestions.
I defer to you guys. You guys make the motions.
30.
Yeah, that's fine.
Let's see here.
While we're waiting, I'd like to thank my wife for waiting. It's our anniversary. She's in the audience.
What's the word we want to use? Not suggest, but
Recommend.
recommend.
Yeah. Strongly recommend. You can say whatever you want. Yeah.
That's a good point, as you say. Follow the recommendation?
Yeah, exactly.
No. Well, okay.
All right.
Are you good, Commissioner Murphy? You gonna make it?
so,
All
yeah.
right, Commissioner Murphy.
Mr. Chairman, I recommend we table to an undetermined date application 202500455-CU-MSP, and strongly recommend a neighborhood meeting 30 days prior to the next scheduled hearing.
I have a motion. Do I have a second?
I will second that motion.
All right, thank you. Commissioner Murphy, did you want to speak to your motion?
Yeah, I think it's,
Can you check to see if fraud's on?
I think it's definitely appropriate. There's a lot of different little twigs going on here as far as information. I see that there's a lot of concerned people, which is very important. And I do feel, from looking at the notes, the first neighborhood meeting didn't go that great from what I saw on the notes. I think this definitely warrants a second neighborhood meeting due to, the type of facility that's going in here, and I think it's completely appropriate. So that's all.
All right, thank you, Commissioner Murphy. Commissioner Birch?
I agree with Commissioner Murphy. There are a lot of people here. They have a lot of strong opinions about this. I suspect we'll see most of you folks again. And I thank you for how polite you've been throughout this entire meeting. It's very commendable.
All right, just Commissioner Wickstrom, if you can hear me, do you have anything? Can you hear him?
We only need a majority of.
Okay, I just want to make sure. All right. Okay, so we'll go ahead and bring this to vote. All those in favor of tabling to an undetermined date with the additional strong recommendation of a neighborhood meeting 30 days prior to the next hearing, say aye.
Aye.
I also say aye.
Rod, or Commissioner Wickstrom, can you hear us?
We'll just take him as an abstain.
It can be an abstain, yeah.
We'll take Commissioner Wickstrom as an abstain. All right. All those opposed, seeing none, just let the record show that Commissioner Wickstrom is abstaining, and the motion to table to an undetermined date carries. Again, thank you all for your time. I hope to see you again. This is how the process works, and we'll have our full body up here to hear. And just know that we're aware of this situation. We're not going to let them string it along indefinitely. I'm pretty sure that we're strongly in agreement that if they continue to table this, that's going to be very, very problematic. So thank you so much. I look to my fellow commissioners for, I do have to approve the minutes from the last time. That's the end of this one, by the way. We're going to move on to like minutes and things. So thank you all for your time. I look to a fellow commissioner to approve the minutes from the June 12th, 2025 meeting.
Mr. Chairman?
Commissioner Murphy.
I move to approve the minutes of the Ada County P&Z Commission public hearing that was held on June 12th, 2025.
Thank you. Do I have a second? Commissioner Birch has seconded. All those in favor, say aye.
Aye.
I also say aye. Commissioner Wickstrom abstain. Thank you all. Meeting adjourned. Thanks. I know. I was worried about that. That was a.
Thank you, sir.